All right, ladies and gentlemen, we're going to recess at this point. These are my instructions. Follow my instructions to the letter. Do not deviate from these instructions. So we're going to be back tomorrow at 1:30 to resume this trial. Now, the parking spaces. If you arrive here by 12:30, you'll probably be able to get a parking space because many times the people who work in this building leave, I call it leaving campus or going off campus for lunch. If you try to come in exactly at 1:15 or 1:20, you may not be able to have a parking space because that's when everybody comes back, because every other court usually starts their afternoons at 1:30. The same number of jurors who came up with you in the central jury room, those are the same number of jurors that will be here tomorrow, and they're looking for parking spaces as well. You do not have to do any investigation on this case. Do not do any investigation on this case. Do not Google anybody's name. Do not look at anything. Do not even think about this case other than when you are in the courtroom. You are not to do your own investigation work. Everything that you're to know about this case is to come from inside this courtroom and nowhere else. Does everyone understand? The deputy is going to make sure that you all have official badges saying that you're jurors of the 187 District Court. Make sure that you wear those at all times when you're in the courthouse, or even when you're walking around downtown, because sometimes, oh, parties, you may be seated, because sometimes attorneys may be speaking about a case. Sometimes people want to talk to witnesses briefly. And if they see you have your badge, they'll know that you're a juror and they probably shouldn't be talking around you about anything. So it's just to make sure that everybody knows that you're a juror. This courtroom, some people say it's too cold. I think it's a pleasant temperature. There is a thermostat behind me. If it would make you all feel better, I can get up. I can pretend to lower, or raise the number. Let me just tell you that thermostat doesn't work. I'm not in charge of the thermostat. It's just there. It's a placebo. But if you ever want me to touch it, you just say, Judge, could you work with the thermostat? We don't complain about it being too cold in here because at one point in time, it would get to be 89, 90 degrees in here. So you can bring whatever jacket you want to bring. I know the chairs are uncomfortable. I'm slowly working on trying to get pillows for every chair. If you want to bring a pillow from home, you're more than welcome to do so. With regards to drinks, you're allowed to bring drinks in, but make sure it has a top on it. We try to keep the rug as clean as possible, and that will protect from spillages. Sometimes jurors they want to take notes. Does you no good to take notes, and this is why. Because if you're taking notes, that means that you're not actively listening and paying attention to the witnesses. Also, if you take notes and during deliberations, somebody wants to know what someone said, you're not allowed to have your notes because the official keeper of the record and what people said, if you don't remember something, is the court reporter. So you won't be able to pull out your notes anyway. People believe that this trial may be concluded by Friday. As I said before, at the latest Monday. Does everyone understand? All right, the deputy is going to make sure that he gets everyone's number so that we'll have your number and you will have our number as well. We cannot start at 1:30 unless everybody is here at 1:30. Does everyone understand? All right, any questions before I send you back with the deputy? Okay, Jess, we're going down the row. All right, we can go off the record. Yes, back row, what's your question? Oh, they're going to give it to the court reporter. Thank you. Other question?
Are we starting 1:30 on Friday also?
No, Friday we're going to start at 9. And Friday there are no other jurors called up. So you'll have parking. Yes. Yes. And you cannot be fired from your by your employer because you're on jury duty. Okay. Now, the other thing, when you meet here tomorrow at 1:30, you will not meet in the hallway. You will not meet in this courtroom. You're going to meet in the jury room. The deputy will show you where that is. In the jury room, there's a refrigerator, there's a toaster oven, there is a microwave. You're more than welcome to bring your lunch, bring your breakfast. No one will touch it. Except maybe one of you, if one of you wants to touch it, but no one else will touch it, okay? All right, any other questions? Yes. We don't do weekends unless you all want to do weekends. So just let me know. All right. Anything else? Remember, yes.
Just curious, what, it looks like you're sipping something.
Oh, so anyway, that's the court reporter and she is a voice recorder. So, but even though she's a voice recorder, everything that everyone is saying, she keeps everything. All right. Is there anything else? All right, so the deputy will show you to the back. Make sure you give him a number where you can be contacted. And on your badges, you'll have the court's number.
Yeah, did the defense exhibits make it to the?
Yes.
Thank you. I mean, it's clearly no harm, but it's still.
Hi. All right.
Have you turned it in?
Oh, I don't have one.
You don't have.
No. So I
All
had to
right.
keep bringing them down.
Everyone, please be seated.
Uh-huh,
That's fine. That's okay. So, when do you all expect to rest?
I would think that we can do all the witnesses and rest our case in chief tomorrow. We'll have witnesses, but I would imagine we could probably do closing arguments Friday morning.
All right, so how long are you expecting your witnesses to take tomorrow? How many more witnesses do you have for tomorrow?
Just
3. So I'm assuming complainant
and then 2 officers.
and 2 officers. All right, so if you all have witnesses, will you be able to have them here by tomorrow?
Yes, Your Honor.
All right, so let's just plan on your having your witnesses here by tomorrow. If something happens, then we'll take your witnesses Friday. But I try to have closing arguments in the morning so that the jurors can concentrate all day.
Yes, Your Honor.
Okay. All right, is there anything else?
Nothing from the defense at the state.
And counsel, we found the,
Oh, my goodness, thank you.
yes, so we'll make sure it stays in the freezer and it does have a band on the back.
Yeah.
So,
That helps, the ice numbs it.
okay, well, when you need it,
30.
just go in the back, it'll be in the freezer.
Yes, sir. Thank you.
You're welcome.
We were supposed to get a chart.
Mhm.
Before we get to our thing.
Yes, let me see if Barbara has
I have
completed that.
video playing already.
Oh.
And we'll be back tomorrow at 9 a.m. for our regular docket, and then they should be back at 1:30. R 012008, State versus Freddie Gonzalez. Can I have the parties announced?
Christopher Ramos and Paul Savero for the defense.
All right. So in this cause number, counsels, have you received all discovery? Did you review it with your client?
We did.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it?
Yes, Your Honor.
Did you understand your attorney and you have certain rights? You have a right to have a grand jury hear the evidence in this case and make a decision on whether or not there's sufficient evidence to hold you over for a jury trial. Your attorney also has certain rights. They have 2 days where they're entitled to 2 days to pass upon presentation of the information to them, and also 10 days to prepare for trial. Did you understand?
Yes, sir.
Did you understand by entering into this plea, you're giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the information with your attorney? Did you understand that?
Yes, sir.
Counsel, do you waive the reading of the information?
We do.
State, are you proceeding on the information as presented?
We are.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Did you understand you're charged with evading arrest, detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and he was.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, yeah.
Anyone promised you anything other than the plea?
Yes, sir. Oh, no.
Has anyone promised you anything other than this plea bargain agreement?
No, no, yeah.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, not allowed re-entry into the United States, and denied naturalization?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $1,000 fine. The state recommends community supervision. This is run concurrent with 2025 CR 005706. I'm sorry. It's 2025 CR 005206. 2025 CR 007487, 2025 CR 007397, 2025 CR 009295. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
That is right.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be a TAP evaluation, 150 hours community service restitution, and the MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offenses charged, how do you plead?
No contest.
State, any evidence?
State offers into evidence states exhibit 1 with its attachments.
No objection.
All right, did you review the waiver and consent to stipulation and testimony with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Sure.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Judge. We ask for it to be mindful that he is gainfully employed right now. This plea is a part of a larger plea that took place 2 weeks ago. The court asked us to return to provide some restitution. And the court also asked the state to provide documentation of restitution amounts. At this moment in time, I don't think that the state has been able to verify the various restitution amounts, but our client does have a significant amount of money to provide in terms of restitution once the state's able to verify those amounts.
We have tried vehemently, Your Honor, to get restitution amounts from all of our different victims. Some have said that they have restitution and will get us the documentation. They just haven't been able to locate it or provide it to us yet. Some have said they don't have any restitution, and there are a couple that we have not been able to get in touch with.
All right, so in this cause number, the 2025 CR 012008, restitution?
On this evading in a vehicle, no, Your Honor.
All right, what about the vehicle? Because it says that the vehicle was damaged with a screw.
Oh, I'm sorry, Your Honor. This one is related to another case. Yes. That is one of the people that we reached out to, and they have not given us any documentation.
All right, how old are you?
30.
You're 30. And this happened on or about May 7th, 2025. Explain this to me. Why are you, honestly, I don't even know why I should accept this agreement you've reached, because you're picking up evadings, forgeries, thefts, unauthorized use of a vehicle, another theft, manufacturing cases, and unauthorized use. So why should I follow any of these plea bargaining agreements?
I can offer the following, Judge. All of these cases deal, for the most part, dealing with financial or property crimes. At the time that he was committing these crimes, he was experiencing significant financial hardship. While that is not an excuse, if you have, not to be harsh, but if you have any sort of discussion with him, he not a very sophisticated individual. And I think as he's described, he took it upon himself to steal this property, sell it for funds, but he didn't realize how he was going to get caught. He thought this was too easy. So he continued, and if you look at the time frame of all of these offenses, they took place within a short matter of time. That's when the offenses caught up with him. He's a very unsophisticated individual. He thought he could get away with this. He was caught. I think even one of the offenses had a GPS tracker on them. He just did not think this through, because I think part of me thinks that he is, not to be harsh, but unable to think this through.
But he's able enough to get a Louis Vuitton belt. A regular leather belt you can get is $20, and you put the LV on it. That leather belt goes up to, I think, a minimum of $350. So he's sophisticated enough to do that. Unless it's a knockoff, and it doesn't appear to be a knockoff to the court based upon my experience.
I honestly wouldn't know how to tell a knockoff from an authentic Louis Vuitton.
Oh no, that's a Louis Vuitton belt.
Is it?
So you want to, yeah,
But
I can spot the knockoffs.
And as the court inquires with him, you'll see that he just is incredibly unsophisticated in terms of being articulate, thinking things through, thinking that he could get away with it. So at the end of the day, he does have significant amount of, I consider significant, to pay the restitution off to these individuals if they can verify the amount. And if this restitution can be made whole to these individuals, it could be to their benefit as well.
All right, and what's the amount of restitution he's here with today?
He has informed us he's in position to provide $5,000 in restitution. All that we ask is that those amounts be verified by the complainants.
He probably could have had 6,000 if he wouldn't have had the Louis Vuitton belt.
Judge, that point, if I may, I know Chris has been, if I may, Your Honor, one of the ways he was able to raise the money was selling things that were near and dear to him. One of the items that he sold, ironically, was his vehicle. So as we speak right now, he is vehicleless, which is kind of ironic considering the charges that he has.
Ironic, but understandable.
And he did liquidate items that he could sell, and he was able to raise $5,000. That doesn't mean he's stopping. He's still trying to sell stuff. And for all I know, maybe the belt is one of the things he's trying to sell. But he has been liquidating his assets. Back to the earlier question, at one point, through hard labor and diligent work, he was able at one point to afford a nice living. He was working in the aggregate business, which is basically shoveling gravel and dirt and so forth. And at one point he was able to make a decent living. And then I don't know if you can notice, he has been having problems with an arm of his that is the result of a birth injury that has been progressively getting worse with his age, and his means of earning that living kind of caught up to him with his disability. Prior to this, he's 30 years old. He has no criminal history. He thought he was going to be able to do something, and he just was not able to. He caught up with it, got caught. And do I feel like he's remorseful? I feel that way. Of course, it's not me experiencing his feelings, but I do. He has expressed regret. For all we know, maybe the regret is because he got caught. But he does express regret. He is trying to show some redeeming value. He has a young child that is about maybe 4 or 5 months old. How old is your child?
4 months.
4 months old. He's never been on any public assistance. He's never received food stamps. He supports his wife. He is legally married. He supports his children. And he just made some decisions. And I've asked him, why did you do this? He's kind of dumbfounded. It just.
And I think he would happily sell his belt in order to add to the restitution. I am mindful that there are some individuals that, and I don't necessarily follow this thought, but there are some individuals that believe by showing respect, by wearing their best, and some people believe name brands is the best as a sign of respect to the court. And I would ask the court to consider his appearance and his willingness to look his best or present himself in the best way as possible.
No,
It's unfortunate that he chose a Louis Vuitton.
no. I only bring it up because we're here because the argument is that he had no money. And based upon that Louis Vuitton belt, that Louis Vuitton belt is not this season. So that's something he had prior to this. And I just based upon my limited expertise in the field.
And of course, Judge, at one point, he was able to earn a living through hard labor. You know, working with aggregate is not an easy.
But why didn't you sell off your Louis Vuitton and all of this stuff before picking up these cases? And why, state, should I follow this agreement?
Your Honor, this was an agreement that was entered into a while ago, and my understanding is that the defendant made strides as far as improving himself, and that was what was communicated to my colleague when they decided to offer this deal.
And what does he do for employment?
Employment right now, he's still dabbling in the aggregate. He's trying to get into the transport of aggregate, and he's working in that avenue right
All
now.
right, when we say dabbling, so is this a full-time job or no?
He has a truck that is in disrepair, an aggregate truck with a trailer, or do you have the trailer also?
Yeah.
He has the trailer also, and they're trying to repair the truck to put it to work.
So he hasn't been working.
No, he still works within the industry, but he's just not making as much money as he.
I'm not driving a truck.
Are you still working?
Yes.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. State your name for the record.
Freddie Gonzalez.
All right, so are you currently employed? What do you do?
I'm working with load. Right now, I'm working with it's the same thing. Well, I don't drive the trucks anymore, but we load them up in the yard and with aggregates and like bays and stuff like that. I'll operate the machine.
All right. Any other questions? All right, this is what the court is going to do. In 2025 CR 012008, court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. This is to run concurrently with 2025 CR 005206, 2025 CR 007489, 2025 CR 007397, 2025 CR 009295, There's to be field visits one time per month for 6 months. There's to be 150 hours of community service restitution. 50 of those hours will be deemed satisfied upon completion of parenting classes. And there's to be, and you say you're currently not driving, you don't have a vehicle?
No.
All right, there's to be no driving without prior court approval.
Judge, may I, just for future reference, the truck that they are working on to deliver aggregate, will you reconsider once that truck is repaired? So they can go to work? Thank you.
And there's to be 10 days in the Bear County Jail as a condition of probation, and that will begin on, and you'll need to turn yourself into the jail. Deputy Mejia, do y'all want him to turn himself into the jail or turn himself in here?
The jail is easier.
All right, so, and you're gonna need to turn yourself into the jail no later than October 10th.
But we'll have a exact date.
Oh, October 10th? Yes. No later than 5 p.m. Did you review the document in that case entitled Trial Court Certification of Defendant's Rights to Appeal with your attorneys? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. In 2025 CR 007487, the court previously found you guilty The court will sentence you to 10 years in the prison, suspended and probated for 10 years. There's a $1,000 fine that will be probated. This will run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396, and 012008. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors. Field visits one time per month for 6 months. 250 hours of community service restitution. 100 hours will be deemed satisfied upon completion of the MRT, which is being required. The remaining 150 will be deemed satisfied once he completes the anti-theft course. And there's to be no driving without prior court approval. And 10 days in the Bear County Jail as a condition of probation, beginning October 10th by 5 p.m. And you'll need to turn yourself in the jail by 5 p.m. on that date. And that cause number, did you review the document? And oh, I'm so sorry. Also, the state is taking into consideration 2025 CR 007488, 007406, and 009170. And Norma, in each of those cause number, I'm going to need a reset date in 30 days for restitution. All right, in that case, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Again, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. Do you understand?
Yes, sir.
And cause number 2025-005260. The court will sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, field visits 1 time per month for 6 months, no driving without prior court approval, $10 days in the Bexar County Jail as a condition of probation. You're to turn yourself in no later than you're to turn yourself in on October 10th by 5 p.m. There's to be 250 hours of community service restitution. This will run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396, 012008. Taking consideration 2025 CR 007488, 007406, 009170. Yes.
I have 225 R005206.
Yes. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. We're moving on to 2025 CR 005205. And that cause number punishment is to be assessed at 2 years in the state jail facility, suspended and probated for 5 years. There's a $1,000 fine. This will run concurrent with 2025 CR 007396. There is to be restitution of $500 to Elizabeth Mascaro. There's to be no contact with Elizabeth Mascaro. And with regards to that complainant, does he have a money order for $500?
Yeah,
Yeah,
cash.
yeah, I have to.
No, not cash. They don't.
He doesn't have a money order, but
Do y'all accept cash?
I don't think they do.
All
He
right.
wants to go get one and bring it back.
So you'll need to have a money order, bring it back tomorrow. Either your attorneys can bring it tomorrow. A money order for $500 made out to Elizabeth Mascaro, and you're to turn it in to the DA's office.
And which case number is that, Your Honor?
That's 2025 CR 005205. There's to be 100 hours of community service restitution, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, no driving without prior approval from the court. There's to be 10 days in the Bear County Jail. You to turn yourself into the jail on October 10th by 5 p.m. And there's to be field visits one time per month for 6 months.
Judge, for clarity,
Mhm.
what is the name of the $500 check?
According to your agreement, it's Elizabeth Mascaro, Mascorro. Did you review the trial court certification of defendant's rights to appeal in that cause number with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak with an attorney. And cause number 2025 CR 007937. Court will sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, no driving without prior court approval, there's a $1,000 fine. This will run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396, 012008. State will take in consideration 2025 CR 007488, 007406, 009170. There should be no contact and restitution to Adam Vasquez. There's 10 days in the Bear County Jail as a condition of probation. You to turn yourself in on October 10th, no later than 5 p.m. And there's to be 150 hours community service restitution. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
And cause, and Norma, if you could start working on the reset form for him. All right, cause number 2025 CR 009295. Court is going to sentence you to 10 years in the prison, suspended and probated for 10 years, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, field visits one time per month until further notice. This is to run concurrent with 2025 CR 005205, 007396, 005206, 007487, 007397, taking consideration 2025 CR 007488, 007406, 009170. There should be no driving without court approval. 150 hours of community service restitution. 10 days in the Bear County Jail. As a condition of probation, you to turn yourself into the jail on October 10th by 5 p.m. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. In 2025 CR 007396, court will sentence you to 2 years in the state jail facility, suspended and probated for 5 years. There's $1,000 fine. This will run concurrent with 2025 CR 005205. There's to be restitution to Mark Crofton, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. Field visits 1 time per month for 6 months. 10 days in the Bear County Jail. As a condition of probation, you to turn yourself into the jail on October 10th, 2025 by 5 p.m. There's to be no contact with Mark Crofton, and there should be 100 hours of community service restitution. Probation in any of those cases, is there any other condition that is needed?
Yes, it goes into 1,000 months until further notice, but all together, first 6 months,
Yes.
no.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it
Yes, Your Honor.
and sign it?
Yes, Your Honor.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, Ms. Ferguson, what date for restitution hearing? All right, so we're going to be back here on October 30th for restitution hearings. Make sure that when you come back on that date, that you have money orders.
May I approach you?
Yes. All right, we can go off the record. Here's the thing. You're old enough now in your life to know better and do better. And there is no excuses for your behavior. You understand?
Yes, Your Honor.
If everybody who had some sort of issue where they lost their job or something didn't go their way, if they decided, you know what, I'm just going to throw my hands up and I'm going to start committing crimes, then where will we be? We will be in the world of Mad Max, and this is the United States, and you're not allowed to do that. Do you understand?
Yes, Your Honor.
So from here on, everything you do, you need to ask yourself if this could result in your being placed in prison for up to 10 years or up at state jail facility for 2 years. If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand? All right, good luck to you.
Thank you, Judge.
You're welcome.
Appreciate your time.
Thank you. All right.
Don't look at my phone, Judge.
Huh?
Don't look at my belt unless it's shut up.
Oh, hey, you know what? My understanding, the goal of a belt is to hold up your pants. That's it. It doesn't have to be fancy. You know, I always tell people for a vehicle, for me, I just want something to get me from point A to point B. That's it.
$8.99 for my belt.
Yeah. So you know what John Wayne always said?
What is it?
He said, never trust a man who wears a belt and suspenders.
Public problem, money order.
Oh, yeah. All right, so we're back on the record in 2025 CR 001454. Defense is your motion. You may proceed.
Yes, all right, this.
You work as much as you're at home,
Uh-huh.
and that wherever you are, you should try to make it as beautiful as possible.
Well, that works.
So you end up looking behind you and then you say, you know what, it's gonna be a great day.
Yeah, that's good. That's
Because
great.
sometimes I will
Uh-huh.
walk to work
Uh-huh. Oh, really?
and you can see the birds chirping, they're
Yeah.
having a good time.
Yeah.
Like, you should be having a good time too.
True, yeah. Yeah. Enjoy the presence. Uh-huh.
Oh, yeah. All right, everyone, I am going to call the docket. Sorry about the late start. I actually am co-judge now with Judge Ron Rangel for the mental health court. So we're going to take up the mental health court docket probably by 9:40. I just need to finish my docket first, then we'll take that up. All right. Adolfo Rodriguez Villafon. All right, thank you. Carlos, oh, that shouldn't be on the docket. Diana Murcia. Josh Randall Sanchez. Raymond Elizondo. And Miss Abrams, that was on the docket yesterday with you. It's 2022 CR 11094. And Austin Michael Young, I think he may be in custody. All right, so counsel, just let me know when you're ready to approach. All right. All right, thank you. While we're waiting, the interpreter, can you tell me, have you received all the discovery?
Yes, I have, Your Honor. And this is, we're applying for pretrial liberation, Your Honor.
Okay, so what I'm gonna do then is I'm gonna give you.
It's
I'm gonna recall you all for October 30th. Could you do a reset form for me on Adolfo Rodriguez Villa thing? And it's a PTD.
Over 30th, that would be great.
Yes. Is that good for you, counsel?
Yes.
Thank you, Adriana.
what was the date again?
October 30th. And for the other, if there's no slot, if you'll just write PTD. And counsel, things should be taken care of with this PTD by that time. So just make sure you do the contract and everything.
Oh, yeah. Thank you. Thank you, Your Honor.
All right, thank you. I'm gonna have to look at that. You know, everybody thinks, every single charge in the penal code.
Oh, yeah. This
But the violation of motor fuel tax requirement,
Yeah.
I'm gonna have to look that one up.
I don't know. It's for, Rodriguez. Yeah, it's an odd one.
Get your hair.
And
Oh, really nice.
LaShawn. So what is happening with Raymond Elizondo? Was he given notice of yesterday?
At what time?
I said that.
So, Judge, on the finance side.
Yeah.
All right. Diana Marcia. All right, Norma.
Yes, wasn't provided with this year, so they notified her,
Okay.
and we started, so.
When do you want it recalled?
Next.
Tuesday of next week? All right, Ms. Ferguson, if you put 2025 CR 11094 Raymond Elizondo for Tuesday of next week. Yes, I think that's the correct cause number. He was on the docket for yesterday, if you don't see him.
Okay. Thank you.
And Deputy Laura, can you make an announcement in the hall for Diana Marcia?
For that case, I show that it was dismissed for PTD on September 15th.
All righty. Norma, that needs to be in the system that it was dismissed.
Yes.
Thank you for checking on that. Diana Marcia, yes. I don't know why these are appearing on the docket when they've been dismissed.
The court can, take the court date off when they trigger this.
That gets overseen sometimes, Judge.
Oh, no problem.
About this.
You guys are asking.
All right, Rashawn, I put it in the system, at least in the notes, that he's being recalled for September 30th. All right, are y'all ready to proceed?
Yes, Judge.
All right, could I have the file on his client, please?
Young?
Yes. All right, so before we go on the record, my understanding is that with Judge Angeline, he had entered pleas of truth,
That's correct, Judge.
and then he was to come back for the outcome of something.
Of a UA. And so he had some food poisoning that day. He'd gone
Oh, but
to
let's get the
pre-trial.
record with
Okay, we can do that. Like,
All right.
it's a little bit of procedural
I
stuff.
was just trying to figure out.
Yeah, there's a story.
Okay. All right, the court is calling 2022 CR 1449W State versus Austin Young. Can I have parties announced for the record for the state
Lauren Espinoza.
defense?
Louis Martinez on behalf of Mr. Young.
And are you Mr. Young?
Yes, ma'am.
All right, on September, I think this is September 11th. You
Yes,
entered a
ma'am.
plea of true to violations 2, 2, and 2. And there was no sentencing on the plea. Off the record, your attorney informed me that you were requested to do a UA or something.
A UA,
Yes.
the 11th.
All right, you may proceed to counsel.
Okay, so Judge, just procedurally. So on the 11th, Mr. Young was released by Judge Angeline provided to go to get UA. And essentially told him in open court, if you clean tomorrow, then, you're just going back on probation. I'll reinstate you. If you're dirty, then you need to go in someplace. Mr. Young called me from pretrial services. I was on the phone with him. We were trying to talk to somebody there about him doing a UA. They kept saying, we don't have anything from the court, so we had trouble doing that. The next morning, Mr. Young had some food poisoning issues, had been at the doctor's, did not come in, a warrant was issued. And then we just tried to regroup and figure out where to go from here. And so Mr. Young brought himself in voluntarily yesterday. One of the things that we needed to address, that we'd addressed with the court, with Judge Angelini, is that in May, Mr. Young was having some mental health issues and some kind of mental health emergencies. And that was kind of the reason for the non-compliance in May. I've got his mother here to testify to that. And so I'd ask the court for to allow me to bring her up and kind of explain what was going on. Okay.
Oh, you need to step over there.
Yeah.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Wendy Scholmer,
All right, and can you spell your last name for the court reporter?
SCHORLEMER.
All right, defense, you may proceed.
Ms. Schuler, obviously you're Austin's mother.
Mm-hmm.
Can you explain to the court what was going on with him mentally in May and what our issues were?
He had, looking back, shown signs of depression, but I didn't know that's what it was. He was not eating a lot, not active. He had a lack of energy, in bed a lot, depressed. He was looking for jobs and getting no luck at all.
Okay, let me stop you there. So he was looking for employment, and obviously the biggest issue is his criminal history.
Yes,
Okay.
the record.
Right.
Nobody wants to even open the door to him.
Okay. And what effect were you seeing on him mentally?
He, looking back, was completely withdrawing and kind of having a mental breakdown.
What kind of signs did you see of him having a mental breakdown?
Withdrawn from everybody.
Did you seek out any kind of medical help from at the time?
Yes.
And what kind of mental help did you seek out for him?
I took him on Sunday. Friday was when I really noticed something was not right with him. He was kind of talking, saying crazy things, not crazy, but just not appropriate things, not in the here and now. And so on Sunday, he was not sleeping either, not eating, not sleeping. So on Sunday night, I ran him up to a little local ER, Methodist ER in our neighborhood.
Okay.
And they did a history, and not a physical, but just talked to him, this cool doctor from Austin, and said, well, maybe you just need to get some sleep. And I was very shocked at the lack of care or concern, but of course I'm his mother. So he said, well, let me give you something to sleep. So he gave him one Ativan. And by the time we got to the car, he was relaxed and he slept that night.
Yeah.
Monday morning, he woke up and became very agitated and talking out of his mind and not eating and just not himself. So then that went on Monday. Monday, we came down to see you.
Yes.
Because I knew he had court Tuesday and I knew he couldn't do it. He wasn't sleeping. He couldn't get dressed. He was a mess. So Tuesday, I took him back. I went to a Stone Oak Methodist Hospital ER.
Okay.
And we waited for hours. And kind of the same thing, a little bit more concerned, but not much. And we sat in a room for hours and the doctor did do some blood work. No blood work, did a urinalysis. And then they gave him something and it made him much worse, much more agitated. At that time, they called in a Bexar County, I guess, policeman or sheriff. I'm not sure who he was, but he was very kind. And he talked to Austin and said, they don't have the facilities here. They don't treat psychiatric patients, but we can just take you in the ER and the ambulance straight over to Methodist Specialty where they can help you.
Okay, and let me stop you. And so was he taken over to Methodist Specialty?
No.
Okay.
He said, no, I'm fine. He said, I'm fine. I said, no. I looked at the policeman. I said, no, he's not. And he said, well, we can't force him to go and you can't either. He's an adult. So they gave him something, made him, I said, he's got to have something to sleep. I can't take him home. He's pacing the floors 24/7. So they gave him one more Ativan. And I said, could you please write him a prescription for just 2 or 3 until we can get to see a doctor? And she said, no, you have to go to Methodist Specialty. We are not a psychiatric hospital.
Okay, let me stop you there. And it's kind of subsequent to that is when we started coming to court and we've had these, the issues with the warrant, those sorts of things.
Yes,
Okay.
yes. And then
And so,
that's yet to come.
okay. Now, had you ever noticed him have kind of a psychological breakdown like that before?
Yes, once before
And when was that?
in high school.
And what were the circumstances of that?
He was having a very difficult time getting through a math class that was required for graduation. He had lots of learning disabilities and he was being bullied and all of a sudden just stopped eating, wouldn't go to school, completely shut down.
Okay. And the situation seems to be kind of consistent with that.
Yes, but the pediatrician at that point helped us and gave us something to get him through it. And with the principal's help and the special education department's help, we were able to get him out of the high school and into a alternative school to finish his requirements to graduate early.
Okay. And so these are the issues that he's been having for the past several months, correct?
Yes.
Okay. And a lot of it is the fact that he's trying to move forward and he's kind of running into roadblocks every chance.
Yes, he can't. He's getting through his probation pretty well in his recovery program, but he can't be a productive young man. He cannot get a job.
And you see the stress that puts on him.
Oh, yes.
Okay.
I mean, one day he said, Mom, there's no hope for me. I might as well just end my life.
Okay. I'll pass the witness.
Any questions?
Briefly, Your Honor. Hello, Mrs. Chung. You stated you observed these types of signs prior to May 25. Is that correct?
Yes.
Approximately what year was the high school incident?
Oh, when he was, let's see, I guess about 18.
And he is how old now?
I'm sorry?
How old is your son now?
39.
So how many years would that have been? About more than 10?
Yeah.
Okay. To your knowledge, did Mr. Young ever acknowledge these signs that you observed in him?
Did he acknowledge?
Mhm.
No,
Okay.
he said, Mom, I'm fine, I'm fine, I'm fine.
And is that in both 2025 and when he was in high school?
I don't remember high school.
Okay. To your knowledge, did Mr. Young inform his probation officer of these issues he was having?
Yes,
Okay.
he
Did you,
talked to him numerous times about the issues of employment. He said, told him to go to Goodwill.
Mhm. But I'm speaking of the mental health.
Oh, yeah.
issues.
I think so. And he discussed, maybe he informed him that he was on a antidepressant.
Mhm. But you're not positive of that, or you are?
No, I'm not.
Were you aware of Mr. Young being on probation?
Yes,
Yes. Were you aware that one of his conditions is to submit to drug testing?
yes,
Were you aware that he violated that condition?
yes,
Would you agree with me that the best way for someone to learn a lesson is to take accountability for their actions?
yes.
No further questions, Your Honor.
And just very briefly, Austin still is on a alcohol monitoring device, correct?
Yes.
And he's on probation for DWI. He does not drive anymore.
No, does not have a car and does not drive anywhere.
Okay, so he gets rides or Ubers or
For
walks.
me,
Right.
me.
Okay. And so, to the best of your knowledge, he is not picking up new offenses, correct?
No,
And to the best of your knowledge, he's reporting to probation.
yes. I know that he missed one time
Okay.
on a Thursday afternoon.
Yes, ma'am. I'll pass the witness.
All right, thank you so much for coming down. Thank you. All right, so here's the court's issues.
Okay.
One, this is not his first motion to revoke,
Correct.
and it's not his first motion to revoke for violation of condition number 2. And it seems every time there is an issue with probation or there is a potential revocation, he doesn't show for court. And something else has popped up where he can't show. And it appears that his issues are the consequences. So I don't know if there's a reason to continue him on probation, because I don't know if there's anything that we can do to help him.
The judge, I'd like him to do UA today if the court would do that. I would, obviously there's some mental health issues. Obviously he's struggling, but I think that the main, there's a lot of things that we ask people to do on probation, but I think the two main things we ask them to do is not break the law anymore and to report and allow themselves to be supervised. And he certainly has been doing both of those things. Our biggest issue when we get DWIs in felony court is the fact that it's not your first DWI.
Mhm.
By definition, it's not. And if you're willing to get 3 DWIs, then, there's an issue. And I think that the most, important thing he's done for accountability is just decide never to drive again. And that's good. That keeps the community safe. So the issue now becomes, how much work do we want to put into him, right? Because, we've got some compliance here, and I think we've got substantial compliance. But if our question is how much more help can we give him, I think that we can. I think that he benefits from the structure. I think he benefits from the supervision. I think he allows himself to be supervised. But, it's not easy to be on probation. It's not easy in this society to have a criminal history because you don't get the same chances other people do. And I'd ask the court to consider a sanction other than revocation. I'd ask the court to consider, there's a recommendation for state ISF cognitive track.
Hasn't he been in
He,
a facility
I think
before?
he's been to SATF before, but we're talking about some cognitive skills. And the main thing is we need to put him in a position to work. And I think like with most people, if he's working, we're not going to have problems with him showing up to court. We're not going to have problems with him showing up to probation. If he's working and he's productive, I think that we're going to get, if not perfect compliance, then pretty close to it. Because he's not a person who is out breaking the law more. He's not a person who is refusing to go to probation. And, in fact, as the court knows, he came in yesterday. He knew he had a warrant. He knew he had missed. He knew this was an issue. And it's not like he went ahead and hid out until he got picked up. He came in to take accountability, to go head on and face his actions. And we know that this court is really good about trying to craft conditions of probation that help a person be successful. And so I'm asking the court to consider that in this case.
All right, state.
Your Honor, the state echoes what the court sentiment that this is not the first MTR or violation of condition number 2. There is consistency in failing to take accountability. We'd ask that you'd grant the state's recommendation to revoke. Mr. Young was given opportunities to comply with probation and take full accountability, but we would urge that partial accountability is insufficient here. He was explained his conditions of probation, and he has shown that through his actions and subsequent violations and then subsequent FTAs on 9/12 and 9/23 that he's still not taking accountability for his actions. So we'd ask that you grant the revocation.
All right. This is what the court is going to do. The court is going to revoke. The court will sentence you to 3 years in the prison, give you credit for any time served, 2-year license suspension. I'll request the therapeutic community. There's a $1,500 fine, time and money to run concurrent. I'll give them credit for any successful completion in inpatient treatment.
Okay.
And let me see. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
The form that we signed when Judge Angelini was here, did you review that form that we signed?
It's the
Yes.
form
Yes.
telling you whether or not you have a right to appeal. You do have a right to, you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you can speak to an attorney. Do you understand?
Yes.
All right. So we can go off the record. So, Mr. Young, it's just that the court has worked with you by giving you inpatient treatment and giving you different treatments to try to help you. But at some point, there is nothing else that I can do. I don't have any more tools. It's sad that the legislature doesn't have more to offer, but I have what I have, and that's it. So you'll receive the credit for any time that you've served, okay?
And
Thank you.
and would you allow him to say anything to the court right now?
I'm sorry?
Judge, would you allow him to say anything to the court right now?
Sure.
You want to say something, Judge?
I don't know what to say, Liz. I'm shocked. I've done everything. I'd finished all my probation stuff. I was just waiting for my, my probation to be finished. I've done all my classes, paid my fine. I had done everything. The only reason I had another MTR is that we had lost the monitor and I couldn't afford to pay the $3,500. And you gave me this
So
thing
here's the
for
problem.
90 days and it's been
This is
over
the
a
problem.
year.
This is the problem that you're not understanding. You had a violation of condition number 2 previously with the court. You pled true to it. I found it true. And I gave you conditions to address that violation. And then you come back and you have the same violations. So when you have the same violations, which were violations of condition number 2, we have nothing else. Thank you, counsel. Yes. Are you here? Because I have to go.
It's an off-docket matter on a federal case.
Oh, that's a federal case where the guy is in custody?
Yes,
Found that case?
Judge Garcia has reset it again into January. There are some major changes coming down on sentencing guidelines on the federal level. I think that's why he did it, because we're having an argument over mixed versus actual methamphetamine.
Okay. Norma, I need a February date for this case. It's DC 2023. CR 1197. The federal case is not set till January 8th. So if you can set this sometime in February. Thank you for letting us know earlier.
Oh, Judge, not a problem at all. Melissa actually texted me this, either yesterday or early this morning. So not a problem to drop by.
All right,
16
so we'll
February.
do, February 16th.
Cream of the different.
It is Joaquin Mendez. Man, that's 2026.
Can you believe it?
All right, thank you.
Thank you, Judge.
Oh, counsel, that's for you.
I'll give it to Norma.
All right, and there's a case I'm going to call. The court is going to call 2025 CR 009957, State versus Josh Randall Sanchez for the state.
Gallery, state.
All right, this hearing was scheduled on September 25th, 2025 at 9 a.m. The defendant did not make an appearance. The court recalled for today. It is now 9:42 a.m. and the defendant has not made an appearance. State?
Requesting a bond. Sure, Your
All right, bond forfeiture will be granted. The defendant will be remanded without bond. If the defendant makes an appearance, the court will reconsider.